Is right to life also a right to die? Who decides the death? The Supreme Court, family or medical board? And what is the legal position of euthanasia, that is mercy killing, in our country? Article 21, as we know, guarantees right to life. But does it guarantee the right to dignified death as well? Supreme Court's latest euthanasia case is the one which forces us to think that what life actually means based on our constitution. Hello everyone, welcome to Vajram and Ravi's Flash News. My name is Shubhangi Singh and today we are going to understand that what has been said by Supreme Court in the latest euthanasia case, because it becomes an important landmark case when we are talking about passive euthanasia. What exactly is euthanasia? What is the legal status of it in our country? And what are the ethical dimensions around it that we should consider? So let us begin with understanding that what is exactly the case that we are talking about. So this case is about a person who has been in permanent vegetative state from last 13 years and the recovery of this man is impossible. Now a petition was filed in front of Supreme Court that the life support that is given to this 30-year-old man should be withdrawn, which is a form of passive euthanasia. The Supreme Court, given the sensitivity of this particular judgment and highlighting that they are only mortals, they have reserved its judgment. Initially, the judgment was supposed to come today itself, but it has been reserved. That means Supreme Court wants to take time to understand the facts, evidences, the situation around it, and then come to a final judgment on this. And this is the case that not only raises the question about Article 21, but it also raises questions about ethics, how life is to be decided that it can be ended. Should it be decided by Supreme Court? Should it be decided by family members? Should it be decided by a medical board? And what exactly should the passive euthanasia framework should look like in our country? And it clearly highlights the tension that exists between the biological survival versus dignified death. Now in this context, the parents of this particular patient have sought withdrawal of life support, citing that there is no chance of recovery and how this is causing emotional and financial exhaustion as well. This appeal was made to Delhi High Court as well, but Delhi High Court rejected the plea and said there is some ambiguity here between active and passive euthanasia, and that is why the appeal went to Supreme Court in this context. Now when we are talking about this whole framework and the judgment has been reserved, the main question remains here: can the continuation of life support be constitutionally mandated by the Supreme Court if the person's recovery is impossible? And that is why the whole framework, whole status of what euthanasia, that is also loosely called as mercy killing, comes into the picture. So when we are talking about this particular case, this is Harish Rana case, it becomes important for us to understand that Supreme Court has said this, that they have a very clear stance on passive euthanasia terminology, that how it exists, and they have also gone ahead and clearly clarified that all of this falls clearly under the category of passive euthanasia. So if they are withdrawing the life support, it falls in the category of passive euthanasia itself. So Supreme Court has clarified this, and court has emphasized that the adherence to the previous guidelines that have been given in the previous rulings, they should be used, and they have also highlighted the distinction that exists between active and passive euthanasia. Why Supreme Court has done this? Supreme Court has done this because Delhi High Court had rejected it on the grounds there is ambiguity between passive and active euthanasia in this context. And there are certain key insights that have also been revealed in this context. So when we are talking about these key insights, they are about common cause versus Union of India judgment that came back in 2018. So to understand this, we need to understand all the the legal precedents here, what exactly they mean, and then we can understand this better. So, we will be coming back to it. So, let us start with understanding that what exactly is euthanasia, often called as mercy killing. So, when we are talking about mercy killing, it basically means that we are deliberately ending life. The life is not ending on its own. We are deliberately ending life because we want to let go of the suffering that the person has to see. So, for a person who is in vegetative state, who cannot do anything at all, there is no sign of recovery, extreme paralysis, instead of elevating their suffering, then there is deliberate death that is being caused, and that is what is referred as euthanasia. So, when we are talking types of euthanasia, we have two types here. We have active euthanasia and then we have passive euthanasia. Active euthanasia is the case where there is an active intervention to end person's life with something external, for example, using a lethal injection. So, that means the person is biologically capable of living. There is some external thing that you are using to particularly cause the death. But when we are talking about passive euthanasia, this is not the scenario. Passive euthanasia in this context, it refers to withdrawing life support. So, if the person is on life support and that is essential to keep them going biologically, to keep them alive, that life support is important, and if you withdraw that life support, then they might not be able to live. So, that is put in the category of passive euthanasia. And over the years, there have been multiple arguments about euthanasia, many in the favor, many against it, but we need to understand it from a whole perspective so as to we know where we think about it, where are we about it, and understand the judgments and also understand the societal feelings about it. So, when we are talking about euthanasia, there are multiple arguments in favor of it that say that this gives death, that too with dignity. That means we are getting to relieve unbearable pain, unbearable suffering. It avoids any sort of futile treatment when there is no hope of recovery. It saves the finances, it saves emotional exhaustion, it saves resources, and also it highlights that how the organ donation from this particular person can go ahead and save other lives. If we talk about Aruna Shanbag case, we got the judicial nod to dignity to death under Article 21 only. But there are multiple arguments against this, against euthanasia itself. Multiple arguments are coming from religious angle as well. When we talk about Christianity or we talk about Islam as well, we get to see it is considered wrong because it is a life is considered a gift from the God. If we are talking about euthanasia, there also comes concerns and risk about non-voluntary euthanasia. That means there might not be consent and it might be misused. And it is a possibility that euthanasia might be used to normalize ending life even for under the less severe conditions. And most importantly, most important factor that we talk in terms of against is that the core medical ethics are contradicted if we bring euthanasia into the picture. The core medical ethics that talk about saving the life at any cost. When we bring euthanasia into the picture, this is the first thing that goes out to the bin at once. Now, when we are talking about this whole concept, this is something that is still finding a place in terms of framework in India, because the legality and the legal framework has not been very detailed defined. Let us try to understand the legal framework of euthanasia in our country. So, the first legal precedent was set from Aruna Shanbag case of 2011. Now, this was the first authoritative ruling on euthanasia that took place in India back in 2011. Now, when we talk about euthanasia being considered, euthanasia was rejected for Aruna Shanbag in this particular ruling, but it recognized passive euthanasia in principle. So, it permitted the latter under specific conditions and it also laid down safeguards. What safeguards? It talked about that how there will be approval by the hospital medical board, how there will be a proper oversight by the High Court, and they also drew a distinction between killing a patient and allowing death in irreversible conditions where there is no scope of recovery at all. So, this was the point where we got to see that the constitutional space was opened for dignified death. And then came in the Common Cause versus Union of India judgment of 2018, where Supreme Court finally talked about right to die with dignity under Article 21, which talks about right to life. This judgment was given by a constitutional bench, and here we got a constitutional mandate for passive euthanasia. It was constitutionally valid. There was a recognition of living will or advanced medical directives that was given, and it emphasized clearly on patient's autonomy, that the patient should get to decide on its own. It talked about informed consent, and it also talked about protection against misuse of passive euthanasia. So where in 2011 this was an exception, passive euthanasia, 2018 it became a right under Article 21. And when we talk about Article 21, which gives us right to life and personal liberty, judicial expansion includes quality of life, autonomy, it includes bodily integrity and dignity at all stages of life, including death from here on. So court clearly rejected the idea that mere biological existence is equivalent to meaning life, and they also clarified that right to die is not equivalent to right to die with dignity. There is a difference here. So if there is a life prolonging treatment without hope of recovery, then that may violate the dignity of the person. And then after, another important legal precedent came through Ministry of Home and Family Welfare draft, which gave guidelines in 2023, which talked about living wills, which talked about advanced medical boards and proper clinical ethics committee for audit and oversight in terms of conflict resolution. Furthermore, in 2023 itself, Supreme Court also simplified the whole cumbersome process into two parts, where one part included primary medical board's presence and its approval in the hospital, and secondary medical board and its presence at the district level, and all of this I am talking for passive euthanasia. And when we are talking about any countries, if you look at global examples, Switzerland bans euthanasia but it allows assisted dying. But if we look at United Kingdom, it is considered illegal and it is considered equivalent to manslaughter. So all in all, if we look at the legal framework of India and the legal status, passive euthanasia, it is legal but with safeguards. Active euthanasia and any sort of assisted suicide is illegal, and the problem that we are facing as a country, as a democracy, in terms of rights here is, as of now, we do not have a proper parliamentary legislation on this. So for a fair clarity, and that is why the Harish Rana case in Supreme Court will be the starting point of the framework which might bring in more clarity on the legals, on the details of it. Now going back to the initial discussion that we were having, that what exactly has the court been outlining. So court has talked about the key insights from the Common Cause versus Union of India judgment, which legally recognized that the living wills and passive euthanasia in India are valid. But in this matter, because of the person who is suffering, they do not have a living will, the court has highlighted that there will be requirement of two medical boards, which we talked about, primary and secondary, and it also should include external medical expert who can review and recommend cases. So based on this, Supreme Court will finally come up to the judgment, and it is also important, Supreme Court has highlighted, because there is no living will, not only medical board but judicial oversight is also very important, because it will ensure terminology and procedures are consistent as per the legal precedents have been set. Now, I hope you have some clarity that what exactly has been talked about in the Supreme Court hearing that has been finally reserved, the judgment has been reserved. Now let us talk about the significance, the importance of this current Supreme Court case. The foremost significance of this particular case is the fact that this is going to be a first clear judicial approval that we will get to see for passive euthanasia, even though passive euthanasia has been legally recognized and very few cases as of now have seen actual withdrawal of life support. So if there is a favorable verdict that the life support can be withdrawn, then this will translate the constitutional theory where the Supreme Court has already said that this is valid. We will get to see that the rights which we are talking about, they are being given, they are being provided, they are being facilitated to the citizens itself. Other than that, this will also bring a lot of clarification where there has been legal ambiguity. It will address all the confusion that is present in terms of active euthanasia, passive euthanasia, withdrawal of artificial nutrition or feeding, or any acts that might be amounting to active euthanasia. So the difference here would be clarified, and it is also very important for the doctors who often fear that there might be criminal liability because the detailing would be clearly done. And this particular case is directly given more strength, more foundation to right to die with dignity, because if we are talking about Article 21, as I said, it is not just about just a vegetative state of life, it is about meaningful life when there is quality of life, there is dignity. So this moves the constitutional morality beyond biological survival, which will give a more defining way to the constitutional morality and how Constitution interprets not just life but also death. Now on this note, I'll be leaving you here with a practice question. Put down your answers in the comment section, and that was all from my side. Thank you so much.